This is Matt Pascucci from CCSI. We have Gabe from STEALTHbits and Paul from Weil on the phone. So we're going to go over a question that we've gotten quite a bit over the past couple months. We've done a few of these webinars, I'd say over the past 3 months. We've done 3 of them. And this is going to be the one that's, the most questions that we've kind of received is, how do you file for the superintendent review that's coming up for your compliance and certification? So we decided that since this is happening in about a week, that we do a quick little run through of how this works, what it entails, and just kind of go through there. This is probably not going to take an hour, but I just wanted to give you guys a heads up. So we are going through this right now. We have a few people on the line that I've been speaking with about this certification over the past couple months. So I've invited them as our special guests for the day. And we're just going to chat a little bit about it. So my name is Matt Pascucci. I'm the Cybersecurity Practice Manager here at CCSI. I've been working with DFS now since it's come out. We've been dealing with clients that have been covered and dealing with how to advise them from a technology standpoint, a compliance standpoint, and just get a better grip of what the pain points are they're feeling. So that's kind of what we're doing here. This has been a very interesting regulation. It's been very prescriptive at the same time. So kind of go forward. It's going to be very, very conversational between the 3 of us. If you have any questions, please put something in the box there, and we will just take care of it after we have the presentation done. But I want to give Gabe and Paul an opportunity to just kind of introduce themselves a little bit and what they've done. So, Gabe?
Thanks, Matt. How are you? So I am Gabrial Gumbs. I'm the Vice President of Product Strategy at STEALTHbits. I've been working with DFS regulation also from its draft inception, as well as I've got quite a bit of experience across a number of different cyber regulations, having been on both the practitioner side as well as the provider side.
Great, thank you. And for you, Paul?
Cybersecurity and privacy practice at Weil, and Manges in New York City. Part of my job is on the regulatory side, dealing with both SEC regulations for registered investment advisors, managers, and funds. And since inception, as you guys, with New York DFS, with the entities that it applies to and what you need to do to be compliant.
Great. So just a little background, guys, everyone else in the webinar. So I've been working with these guys over the past couple months. I did a presentation and a panel with Paul, I'd probably say about 2 months ago, and very impressed by his background and the things that he can bring to the table, as well as Gabe. I've known Gabe for a long time now. So they're bringing together a combination of both technical and very regulatory and compliance skills here. So the questions that you might have that you're always afraid to ask, please put them in. We have the talent on the phone now with these guys here that can really answer them, and I'm excited to see what we can do together. So quick overview. February 15th, the day after Valentine's Day for the guys on the phone, we have to have all of the covered entities here have to go out and submit their regulation of compliance. This involves, we're going to find out later on, going forward and submitting that to the DFS. There's 2 particular methods that you can do that. There's a preferred method and an alternative method. We'll discuss that briefly in a few minutes. But this is just kind of the roadmap of where you have to be in 2 years. Look where we are now with the arrow. So we are really just getting started with DFS with this regulation. So there's a lot to do, and we'll go forward a little bit and kind of breach into what that means for this particular submission. After the 2 years is done, all this has to be done, but what has to be done now? And that's kind of the question that we've been receiving over the past couple months. So what needs to be done to be compliant? So you don't have to boil the ocean. As I said, you don't have to have all these phases done. What you have to have done is the first transitional phase, which is cybersecurity program, a written cybersecurity policy. You need a CISO, either a CISO or a vCISO, incident response plan, and notices to the superintendent via security events and such. From that perspective, I know Paul and I have had some back and forth. Paul, can you go into the background of a difference between a cybersecurity program and a written cybersecurity program? We've chatted about that a little bit, and I know that was something that you really wanted to hit on.
Yeah, I just wanted to draw a distinction, Matt, between Section 500.02, which talks about the covered entity having a cybersecurity program, which is sort of I would call it a holistic view of the company's cybersecurity based upon its risk assessment. This is sort of where's my stuff? What data do I have? Where is it located? Do I have the ability to detect an adverse event? And do I have an incident response business continuity program to respond if something bad happens? I just wanted to distinguish that, Matt, between a cybersecurity policy, because that policy is a loaded term under 500.03, which talks about an information security policy, a data governance policy, asset inventory policy, access controls, or IAM, business continuity, and the like. So, though it sounds it doesn't sound bad when you're talking about a certification, there's actually a lot to it. Yeah. And I wanted to make sure our listeners understood that this was just not mail in something to DFS and you're fine.
Yep.
You're not fine.
Yeah, good. So we're going to have a little bit more on that, on just what needs to be done in a few slides from now. But no, that's a very good point. So not just because you can go hit here and hit submit that you're fine going forward, but you're going to have to do some work, and you're going to have that proof and evidence going forward as well. Those are good points. But as you can see here, I'm sorry?
I was going to say, before we move on to the next slide, I certainly wanted to make sure we touch more on the CISO and vCISO initiatives as well.
Correct. Yeah, so that's a big point. And a lot of the smaller covered entities might not have a CISO. So being able to decide what that qualified individual is kind of a big point. Something that we've gone over quite a few times as well. But it's definitely worth bringing up again, because this regulation has kind of called it out that you must have someone in that role, and not only that's someone that's just going to be a random someone in IT or someone that's in your audit field, but it mentions qualified, and there's a lot to that backing, that someone who's qualified, who has that business acumen and can really understand that. So that's a good point. But also from this, as you can see here, everything that's going to be going into the second transitional phase that's coming up in March 1st is not required for this submission. That's actually within the FAQ on their site. So the penetration testing or continuous monitoring, the risk assessment requirement, multi-factor, that is not to be taken into effect up and coming with this filing on February 15th. That does not make you secure. Paul and I, we were chatting about this before. It does not make you secure that you don't have it, but it will make you compliant for this perspective. So, keep that in mind. So submitting for the certificate of compliance. So I'm assuming here that most of you hopefully have logins to the NYDFS site. There are two particular ways to do this. One of them is going to be and I have the links down here, it's going to be Appendix A within the documentation or through the DFS portal. Now, with going through the FAQs here and going through DFS's recommendations, is they want you to go through the portal. They recommend you go through the portal, essentially because they're saying that it's more secure. You're really not doing anything insecure by submitting this, but they want to kind of funnel everything there. It's going to be easier for them. Their wording is the filings made through the DFS web portal are preferred to the alternative mechanisms because it provides a secure reporting tool for compliance requirements of 23 NYCRR Part 500. That's their verbiage. So we're going to go into where and how you get there, but that's the documentation here. So if you go to myportal.dfs.ny.gov/web/cybersecurity, that will bring you to the portal where you will be submitting for this compliance. It is their recommended way of doing it. So is there a particular format on this? So there's a lot of back and forth. That link is not within the guidance of the regulation. It's just within their FAQs. So you kind of have to hunt for it. This is the first time it's happening, so I'm assuming they're going to go forward to make that a little more clear. But within the regulation, there is the alternative way of submitting it, which is Appendix A. So they kind of give you a form and what they want to see with, with the board of directors and signatures and such. So we will show you what that looks like here. That's in the regulation. That is the alternative way of doing it. So that is something that you would go in there, you would file it, you would put your date and signature and send it up to DFS at that point. Doing so requires a lot more work than going through their preferred method, which is going to their actual site. This is the way that we would prefer and recommend that you do that, just because it's easier. You're on the web, you're pushing it through, and it's going to come. You're going to get a timestamp. It's going to be electronically timestamped. So it's much easier, and the DFS is recommending you do it that way too. So at this point, I'd follow the recommendations, to be honest. But going to that site, you're going to have the email address there that you're signed up with your covered entity. You're going to log in. Pretty simple. We're not breaking any new ground here. But once you get in here, you're going to see 3 different boxes. We should probably go over the other 2 at other webinars. But the one we're looking for is the Submit Cybersecurity Certification of Compliance. The other one is if you have an exemption. So if you have an exemption, that's where you're going to be going. If you don't meet particular requirements, or you have issues that you like under 10 people working for you, that kind of stuff, you would go there, you would file for a particular exemption, and you would follow that process, as well as the cybersecurity events. This is something that's important. You can go through the regulation, needing 72 hours to go out there and put events in there of information that has potentially been breached, that's been non-public, and following that procedure. But to get compliant, this is where we're going. We're not going to branch off anywhere just yet. To stay compliant, we are going right now for the submission, and we're clicking on here, right? So once you click on that one right there, you hit the Submit Cybersecurity Certificate of Compliance. You'll be brought up here with confirmation that this needs to be done for the past year, right here from January 1st to the February 15th of this deadline for your covered entity. You're going to hit Submit here. You're going to proceed here. And then you're going to start getting into your particular covered entity. You put your name in there, so you have to be a covered entity. It's already covered by the NYDFS. You should show up within the name of entity. So if you start, beginning to type your entity in there, you will pop up and you will select that. And you will have now the ability to fill in your entity name and your ID. Everything will fill in there because you've already been certified by NYDFS. Now, something to say here. I have reached out to this email here, the cyberreg_comments@dfs.ny.gov. I have never gotten a response from them. I don't know if it was just me, but I've tried contacting them directly a few times. So this is one of the reasons we're trying to go out there for our clients now. Is it seems a little difficult sometimes with this being a new process to reach out and get hold of someone that's there. So one of the reasons that we're currently doing this webinar is to just kind of educate and kind of guide people for the first time. But you would put it in there, your information would be filled in after your entity name is selected. You would hit next, and this is where it now gets that back and forth, right? So either board of directors or senior officers. So if you hit the radio button for board of directors, you're gonna put all the board of directors' names within there and the date of the board resolution for compliance findings. So you put that as well, and here you would click here and it would pop up with the dates you could select there. If you don't have a board of directors, if you have a senior officer, you would click Senior Officer tab on here. It would show something a little bit different where you're putting now the titles of that particular senior officer. So depending on how you are filing as a covered entity within that responsibility, this is the way you would go through things. So Paul, this is a question for you. At what point, we have some questions that are coming in right now from our Q&A. So if you don't have a board of directors, who is someone that is qualified as a senior officer, or is there a particular type of role that should take that place?
Well, Matt, you raised upon an interesting point that isn't necessarily covered in the reg. To me, if you didn't have a board of directors, maybe you have a board of managers, or you have a general partner, of a limited partnership. I think you need to provide some person in a senior enough role that is a person of responsibility over the cybersecurity function of the entity, not the CISO, but somebody on the business side that has that senior role and senior responsibility. So I look at this as I've looked at other regulatory roles. You see this throughout the SEC regulations. You're talking about, you see this through the FFIEC regulations for banks. They want a senior director, senior officer, senior person involved.
Now, from that standpoint, this senior officer is putting their name on this certification. What is the legality to them if this is now found out to be either not true, or there was things that were holes involved, or they're breached? Is there any legality on them directly? Are we holding this particular person responsible?
That's a big loaded question, so of course I won't answer it the way you asked it. But I think that, to me, this is a senior business person, a senior person with responsibility. We all know are going to be breached. We all know that things will happen. We all know that there's no perfect cybersecurity. So I think this certification is a function also of having policies, procedures, training, looking at third-party vendors, just making sure you're covering the gamut of what could happen to you. Mm-hmm. You could have a breach, DFS could come in, and they might find that it happened and no one's at fault, and that's the way it is. Or if you don't have what they call in the regulation an audit trail, meaning some ability to cover what you've done or what you haven't done, and I'd point everyone's attention to 500.06. These are, allows you to have ability to understand what happened. You have to have an audit trail for 5 years. And, I think we should probably not think of this as a legality. This is a problem, at least in the first instance. I mean, I think obviously you could have something where there's severe neglect and to the point of invoking a legal standard. To me, it's a responsibility. We're going to get breached. You're going to have problems. Have you done the best you can to comply with the regulation?
Got it. And Gabe, from your standpoint, having worked with PCI and GDPR, from an audit trail perspective, do you see similarities here?
There are significant similarities. In fact, I actually see more similarities with SOX than I do, for example, with PCI or GDPR. Neither of those regulations really call for nearly as much audit tracking, but unsurprisingly, SOX does, right? As a regulation that deals closely with financial transactions, the ability, or I should say, the necessity to always be able to look backwards and attest to what occurred. In SOX specifically, it calls for things such as, understanding who made what changes and or what level of or what was accessed along the financial transaction path. DFS is similar in that respect, where in the first part, the first 180 days, it called for that least access privilege model, and although not explicitly stated, what is required there from an attestation perspective is being able to not just show who has access to what, but what has been done with that access. That's always going to be an important part of any financial regulatory requirement.
Got it. Yeah, so it's just understanding who has what access to what and what they're doing with that data. So, gotcha. All right, so once you have that done, so thank you guys. Once again, you come up here. This is going to be pretty much your signature page to it, and you're going to hit the I swear or affirm button there and essentially submit it there. Excuse me. So this is pretty much your written acceptance that's going to be dated on there, so it's going to have the timestamp of the date. And we were talking briefly before, and we had a few other questions here, but it says by February 15th, and if you have it by February 14th, you're fine as well. We know people here who have already submitted this. It's by February 15th, not have to be on it. You can be on February 15th and still be compliant. You can do it right now if you really needed to. So these are things that questions that we've had people have asked us over the past couple of months. But hitting submit to that will push you through the policy and get you ready to be compliant for this particular annual reoccurrence of the certification. But so with this documentation, one of the things that we've been had a few people ask us is what else has to be submitted. Now, if you go through the regulation, you go through all these phases here, nothing else has to be submitted. So, the FAQ says, you do not have to have anything else submitted with this certification here. A covered entity is not required to submit explanatory or additional materials with the certification. So I know there was some confusion before with a few people that we had spoken with on what do they have to do. Do they have to have the CISA report in? Do they have to show all the events that have occurred? Is there any type of metrics that have to be submitted? And at this point, all it's saying is you have to go through that and on your understanding of where you are with your program, that you've done the due diligence, and a lot of this is going to be brought up later on. And this is where Paul was talking about the difference between a cybersecurity program and a written program, and certifying that by understanding the evidence that you currently have in place there. So, and I'll just go over this really quickly, but guys, feel free to jump in. But some of the evidence that needs to be kept, and you need to be keeping those records. 500.17. Pretty much goes over, to identify areas or systems or processes that are already there. So if you're doing any updating to your systems or a redesign or anything along those lines from the covered entity, you should be keeping track of that. So the change control should be there. Any type of security events should be there. They should also be submitted to that one little box you saw in the beginning on where to submit them. But these are the things that once this comes through, once this evidence comes through that you're showing you're doing your program, that you're not just kind of willy-nilly going through it and not keeping record of anything. That's part of the DNA of keeping a program together. Is there anything there, Paul, that you'd like to add regarding just evidence and documentation?
That's a great question, Matt. And I always tell clients, when something happens to you, you're always going to be looked at in the rearview mirror.
Yep.
What have you done for me lately? What programs, policies, and procedures? So, we look at this holistically as a cybersecurity program with lots of different policies. And you said something earlier about pen testing or vulnerability assessments. We tend to think here proactively about doing more than what the regulation says you need to do.
Yeah.
So again, I'm not saying you have to, but when looked at in the rearview mirror, you get a bad breach. The fact that you've done maybe your vulnerability assessment, your compromise assessment, again, these are terms of art that the cyber guys on the phone understand much better than I. You have at least an ability to say, hey, Mr. Superintendent of DFS, or in this case, her, ma'am, I did the best I could. And I want clients to be in that position. I think just checkbox compliance is not the right approach when you're coming to cybersecurity.
Yep. So this is pretty much you're covering yourself because you're going through the process and you're saying, we got breached. It happened to us. No one's bulletproof. But here's the things that we did. Here's the evidence of us going through, actually trying. We're not just trying to pass compliance. We're not trying to do a checkbox. Here's actually what we're doing. Besides that, do you think right now, this is one of the questions too that have been brought up to us, for that first transitional phase, is that evidence going to be required right now?
I can't sit in the shoes of the superintendent. I think every organization has to make a business judgment about what they can do, what they can do, what they can afford, and what they can't afford.
Got it.
If you ask me what my opinion is, I think again in the rearview mirror of you've been breached and stuff was stolen, you should be able to show you went the extra mile. That you did more than what was required here, that you listened to the superintendent of DFS, you paid attention, and you did the best you can.
Yeah.
And I think this bears out. I'm sorry to speak a little longer.
No, go on.
This bears out with other breaches that we have seen, and in fact, the DOJ's thought process of let's not call the victim of a breach a knucklehead. Let's call a victim a victim. And in many cases, you are the victim, but you can't be the victim who did nothing in the face of a regulation like this. I would rather have a client of ours, if they did have a breach, and God willing they won't, I'd rather have a client showing they made a great, they complied with this regulation, and in fact they did more than they needed to do. I think that puts you in a good spot.
Got it. So, going forward, we had spoken to a client a few weeks ago, and they were on the fence. They were like, "It's very gray." One of these sections they were talking about, and I was like, "Well, take it as hard as you can, because if it ever came down to it, if it was gray and you did less, and you get hit on it, now you have to try to prove it out, and now there's already, from an audit perspective, there's a blemish. So as much as you can, as much as you can afford, continue to move forward with the regulation as it's written." There are a few, I think, common legal misconceptions. This is more going to guide towards you, Paul, and Gabe. If you have something, feel free to chime in. But one of the ones I've heard from a few people that are even in banks is that the NYDFS won't have the resources to audit all of us. What is your opinion on that, Paul?
That's baloney.
Yeah.
My favorite sandwich, of course. But DFS has trained people, not just trained auditors, but trained cybersecurity auditors. I've heard of audits taking place that have been very comprehensive. Again, every audit is going to be different. All personnel is going to be different. I would not rest upon the fact that you're going to get some passive auditor who doesn't understand cyber or doesn't understand the regulation.
Mm-hmm. And are they doing this right now, or are they waiting for the first submission?
They are in people's offices. It is my understanding they are in people's offices today doing things that are prescribed under the regulation. Mm-hmm. Obviously it's a regulation that has a graduated approach, so not everything is automatically applicable. But I wouldn't want to be a bank or a private equity fund or an insurance company that sat back on its laurels waiting for a drive-by audit to take place.
And do you see these guys kind of like tagging in with the feds, or is this something where they're just going to start sending out like ad hoc requests of coming in within 2 weeks? What is your opinion on that?
My own humble opinion is I don't have one. It's very too early in the mix to understand. You can have clients obviously that are both fall under SEC OC guidelines as well as DFS guidelines or the FFIEC guidelines. I think I think if I had to describe this again, I see this as a who's responsible approach, that there needs to be somebody responsible for the cybersecurity of this organization, somebody where trust is invested in, and that takes his or her job seriously, that this could be a big problem and there could be privacy, a big breach, and PII or PHI stolen. We've seen enough of it already with Equifax and Uber and others. I don't want to be the poster child if something happens and DFS comes knocking at your door.
Yep, I hear you. To that particular vibe, what are the fines? And I know they're based off New York banking law. Are you familiar with what the fines could be or when they might occur? So say for whatever reason you are found now that you are delinquent on this, or that there was just, pure negligence on it. Any opinion on the fines? Because that's another one that we get a lot too. Is how and how much and when could a covered entity be fined?
I don't have any opinion today. There's no history. If you ask me about HIPAA and OCR and others, I could give you a history. Mm-hmm. I think I get back to, Matt, who's responsible? Did they take their job seriously? Did they read and understand the guideline? Did they comply? And, in my own mind, did they go the extra mile to make sure customers' data was secure? And if they did, you're in a good position even if you do get breached.
Yeah. Okay. So once again, follow the guideline as hard as you can. So we went over a little bit about the historical evidence that needs to prove this. So, keeping with all the notifications, keeping with the change control, keeping with any type of changes that are occurring within your organization, these are things are good to prove, as Paul is saying, to go out there if there was ever an issue to show that you are serious about your security and just having an understanding that you will be audited. It's going to happen. So take it serious because the New York State is taking it serious. And from that perspective, that is essentially all we have here. We do have complimentary risk assessments, so if you want to set up a call, we can go over a couple hours one day, just kind of give you a risk assessment of where you are and how you fit with DFS, things we've seen with other clients. Completely free. This is something that we're doing just to keep the conversation going. This is the after party. But we also have, Gabe is on the phone here, and we have STEALTHbits. He is running with that product. We are huge fans of it here at CCSI. We have it in our lab right now. If you have any questions on how that can bring up, help you with the audit, help you with your data governance, big, themes within DFS right now, feel free to give us a call. We can go through that with you. We have quite a few customers of ours now that have been using that to help them comply with certain areas of DFS right now. So very helpful. Gabe is always helpful, and we have it in our lab too. So if you want to give us a call, we can spin it up and show you it within probably a day. But with
it's
that,
also worth mentioning, we also have a compliance toolkit that will explicitly show the mappings between how CCSI is able to actually meet the individual requirements of the standard, so that you can see exactly how that relates, not simply kind of not just a high level transparent way, but a very concrete mapping of the offerings.
Yep, and it kind of just maps into the regulation and how these tools that we can use and how we can work with them to comply. And as Paul was saying, to show the evidence that we're going above and beyond. But we do have 2 additional questions that were submitted. One, this is a good question. I'm going to see, Paul, this one's for you. Do exempt companies have to submit this as well?
Huh.
Yeah.
I have,
That's a good one.
none of my clients are exempt, and therefore I haven't studied those guidelines yet, but we can certainly get back to you and take a look at them.
I'm going to go out on a limb here and say with the exemptions and with the types of exemptions, you're exempt from certain sections. It doesn't say you're exempt completely from the regulation. So I would go forward with the particular sections of the regulation that you are not exempt from to validate that you should go forward anyway and submit. That would be my opinion of it for right now, because depending on your exemption status, it means that you're not going to be doing a full particular review of all the sections, but you'll be mandated to do the ones that you're required to. So my opinion on that, to be honest, would be as saying, take the hard line, go forward, make sure the ones that you are not exempt for are completed, and you have the evidence to support that. And the last question. I'm sorry?
Well, before we move on, I might be willing to throw in there that New York State itself does have breach notification laws. So even though one may be exempt from certain or all parts of RR 500, you probably want to take a look at Section 899 AA of the General Business Law for New York State. There are some applicable incident reporting, breach notification, and other guidelines there that one does still have to be aware of. And there's obviously the civil impact of any such breaches. So it's fair to say that in 2018, as it was true, as much as it was true in 2017, 16, 15, and so forth, that not necessarily being beholden to any one strict regulation does not make anyone exempt from having at least sane cybersecurity hygiene, right? And one of the things that I personally like about RR 500 is the recognition that not everyone will be able to have that type of talent or technology in-house, and giving allowing some leeway for those things too, right, with VCSOs and so forth. So I certainly suggest that everyone at an absolute minimum familiarize themselves with the New York State breach notification requirements and laws as well too, if they do fall outside of our R500.
And with that being said, thank you, Gabe. That's very helpful as well, knowing that there's, just besides this, the state does have other recommendations to do. But with the exemption status, depending on which one you're exempt from, it kind of differentiates itself between the exemptions, but they always have the risk assessment. You're always going to have data retention policies. You're always going to have these third-party reviews and incident response plans. So you're going to have, with the exemptions that are already out there, those particular 4 are always mandated. So, depending on where they fall within the transitional phases of the ones that are always going to be mandated, I would validate that if this phase is now passing now, the first transitional phase, you're going to have particular policy and procedure done anyway. So make sure that's in that first phase, make sure that's done. So these are the type of things, depending on your exemption status, determine which ones you are exempt from. The ones that are now left when the dust has settled, see if they're in the first transitional phase and make sure you have that evidence and that work completed, because you will be responsible essentially for that. Did you want to say something else, Paul? Sorry, I think I just cut someone off.
No. That was
Okay.
that was an excellent point, and the regs are pretty clear that though you may be exempt from some part of the rules and requirements, you're not exempt from everything. And Gabe's point on state law is also a very good one. Until we have mandatory federal breach notification law, we have 48 states with 48 different rules and regulations. So it's a lot of fun when you have a big company.
Yeah, and exactly.
Fun. I'm not sure that word means what you think it means.
So
that was being facetious.
That's right.
And the very last question we got in saying, can this form be submitted and completed by a CISO on the behalf of a senior officer?
That's not what the regulation says.
Exactly. So
So I would not read this regulation as guidance. I would read it as a regulation.
So I agree with you there. So unless, and correct me if I'm wrong on this opinion, but unless you are considered the senior officer and the CISO at the same time, I would probably try to separate those two, just to do more of a separation of duties, to be honest. Because now you're getting someone who's kind of running the policy and procedure and the program itself also being the one to sign off on it, when you kind of want to have someone from the business side. That's how I'm currently reading it. But yes, I agree with you, Paul. I think we should have someone more from the business side, being the person, an individual as the senior officer signing off on it.
Correct.
Okay, guys. So we have no further questions. I want to thank you, Paul and Gabe, for kind of throwing out some knowledge on there and making this a little more clear for our listeners here. So once again, thank you guys so much. And with that, we will be shutting down. So any other questions?
I really appreciate it.
No, thanks, guys. Thanks for coming, Gabe. Thanks, Paul. Thanks, everyone else. Any questions, shoot us an email. If you need to talk to Paul, we'll have his contact information sent out. If you need to talk to Gabe on STEALTHbits or anything, we'll have that as well. So once again, thank you, everyone, for joining, and we will see you on the next one. See ya.
Thanks, Matt. Thanks, Paul.
See you later, guys.
Cheers.
Bye.